For producers with unwritten farm leases, the deadline for legally terminating those agreements is approaching. Earlier this week, we talked with Nebraska Extension ag law specialist Dave Aiken to take a look at what happens after the September 1st deadline.
After September 1st, if the landlord and tenant can't come to an agreement on the new lease, it's too late for either one of them to terminate the old one, so they have to both agree to let the other party out.
Where does this date come from, September 1st?
Well, the Nebraska Supreme Court has said that the farm lease year in Nebraska begins on March 1st, and that you have to give 6 months notice in advance of the new year if you're going to terminate. So that's where it's September 1st.
Compared to a written lease, which would terminate?
Written leases terminate on the last day of the written lease unless there's a termination clause or a renewal clause that sets something different up.
All right, so what happens on September 1st if the landlord and tenant don't make a change?
Ordinarily, my recommendation to the tenant is that they try to make a deal, because if the landlord is unhappy and the landlord is held to a deal that the landlord doesn't like, the tenant isn't going to have the lease for very long.
Right. What about this year's tenants wanting lower cash rates, which I'm sure they would want at this point in time?
Yep, this is the flip of the typical situation. Typical, it's the tenant who's trying to hang on to last year's deal. Now it's the landlord that say, yeah, last year's deal looks great to me.
Right.
And so the roles are reversed, and it's the tenant, who wants out, and the landlord kind of wants to hold him. So, if the tenant doesn't give notice by September 1st, the tenant could be locked into last year's deal, which could be a bite.
What could the tenant do then in that situation?
Well, negotiate as the landlord and try to come up with a written deal, the best deal that they can. But it's a hard decision for them to make, because if it's a bad deal for them economically, then it's not an easy call.
Other than the straightforward things, why are written leases so important when you talk about renting land?
Well, it's good because it forces the landlord and the tenant to address issues that they wouldn't ordinarily think of. Normally they're just thinking of, what's the rent going to be? But, you need to think about what happens to one of the parties. They get sick or incapacitated, something like that. What happens if the tenant's check bounced, rent check bounces? What does the landlord do? How are they going to share production expenses? Are they going to make any changes in that? Right of entry, hunting rights. All these sorts of things are things that you might not think about, but if you're working, especially with an attorney, hopefully they'll point out these potential issues that could come up, so that you can talk about them, and then if something happens, you've at least talked about it before. You've got something in the lease.
So September 1 comes, there's no agreement. Can you still keep negotiating?
Yes, and typically that's what happens, is that they'll keep negotiating, and hopefully they can come to a deal. But if they can't come to a deal, then it's last year's deal.
Does the 6-month notice also apply to pasture land?
Not in Nebraska. This is not really as clear as we would like, but there's an old case that suggests it just applies to cropland, so that's the best we have for now.
Where do you recommend farmers, either tenants or landlords, go for more information about developing ag leases?
A great website is aglease101.org. It's got educational information. It's got blank lease forms. It's got worksheets to calculate rents and stuff like that. And so, it's got a lot of great information, but I recommend that landlords and tenants work with an attorney, in developing their particular lease.